Okay, good afternoon. Okay, let us continue our discussion on negotiable instruments. Okay, ginawa ko tong part 4. Okay, bali nag-stop tayo dun sa, okay, kay Eva case. Okay, sa case ng State Investment House versus Court of Appeal. Okay, now let us now discuss yung section 54. Okay, yung previous yung section 53. Okay, 52 saka yung 53. Bali yung 52 yung requisite ng holder in due course. Tapos yung section 53, applicable yun sa instrument payable on demand. Now, sa section 54 naman, ang question dito is that, pwede ba kayong maging holder in due course at the same time a holder not in due course? Okay, the answer is yes. Okay? Bali, ang tawag sa inyo dito ay partly holder in due course and partly holder not in due course. Now, let us cite first the legal provision. Okay, under Section 54, when the transferee receives notice of any infirmity in the instrument or defect in the title of the person negotiating the same, before he has paid the full amount agreed to be paid therefore, he will be deemed a holder in due course only to the extent of the amount therefore paid by him. Okay, kaya lumalabas dito, magiging partly holder in due course ka and partly holder not in due course. Illustration. A issued a promissory note payable kay B or order. The consideration is that B will deliver to A 100,000 worth of supplies or materials. Okay, however, si B, ninegotiate niya kay C. Yung promissory note. Okay, ang consideration naman nun kay C is si C magdi-deliver kay B ng 100,000 worth of materials din. But before, okay, but C already delivered the 60,000 worth of materials. Okay, but before C could deliver the balance of 40,000. Okay, bago niya ma-deliver yung balance in 40,000, nalaman ni C na yung title pala ni B was defective. Now, under the law, section 54, si C, holder in due course na for the 60. Pero hindi siya pwedeng maging holder in due course for the 40,000. Kasi meron na siyang notice of infirmity of defective title. Absent na yung requirement ng section 52, paragraph letter D. Kaya lumalabas, holder in due course ka for the 60 and partly holder not in due course ka for the 40,000 pesos. Okay? Yan yung section 54. Kaya punta naman tayo sa section 55. Okay, when title is defective. Okay, sabi ng section 55, the title of the person who negotiate an instrument daw is defective within the meaning of this act when he obtained the instrument or any signature thereto by fraud, duress, or force and fear, or other unlawful means, or for illegal consideration, or when he negotiate it in breach of faith, or under such circumstances daw amount to a fraud. By the way, dalawa yung binanggit sa section 55. Acquisition, saka second is negotiation. Ibig sabihin, in-acquired mo raw yung instrument or signature by fraud, duress, force and fear, or other unlawful means, or for illegal considerations. Yung pangalawang part is, ni-negotiate mo siya in breach of faith or under such circumstances amounting to fraud. By the way, yung nakalagay sa section 55 na defective title, lahat yan is a personal defense lang. At hindi yan pwedeng gamitin, okay, as a defense against a holder in due course. By the way, I mentioned fraud. Sa negotiable instrument law, may dalawang klaseng fraud. First, yung tinatawag na fraud in pactum, okay, or fraud in esse contractus. Sa akin tinatawag na simple fraud or fraud in inducement. Yung fraud in factum or fraud in esse contractus, real defense yan. Yan tinatawag nating fraud amounting to forgery. Okay, and that is a real defense. It can be set up against any holder, including a holder in due course. Pero yung simple fraud kasi, personal defense lang. Okay, kaya hindi siya available na defense against a holder in due course. Pero syempre may tanong ka, sir, paano namin ma-identify kung yan ay fraud in factum or fraud in esse contractus o kaya simple fraud lang or fraud in inducement? Okay, simple lang. Kapag fraud in factum or fraud in esse contractus, okay, kung halimbawa nag-sign ka ng blank paper for autograph signing lang, ang problema, without your authority, kinonvert yan into a negotiable instrument. Okay, ang defect niyan mismo, dun sa instrument itself. Kaya lumalabas, that is a fraud in factum or fraud in esse contractus. Hindi ka kasi aware, okay, na yung pinirmahan mong blank paper pala ay i-convert into a negotiable instrument. Pero kung halimbawa, okay, may binebenta sa yung sing-sing. Sabi, 18K gold to, okay, naniwala ka naman. Kaya inisyuhan mo ng promissory note. Ang problema, na-negotiate yung inisyu mong promissory note sa isang holder in due course. But later on, na-discovered mo, yun palang ring ay okay, hindi 18K gold. Kaya ang tanong, yun bang holder in due course dyan, pwedeng ma-enforce yung instrument against the maker? The answer is yes. Kasi yung defense mo dito is just a matter of a personal defense. It cannot be set up against a holder in due course. Now, anong pinagkaiba niya? Doon sa una, okay, nung pumirma ka, hindi ka aware na i-convert pala siya into a negotiable instrument. Kaya lumalabas, okay, that is a fraud in factum or fraud in esse contractus. Yung second illustration ko, lumalabas, nag-sign ka nung promissory note at fully aware ka na ito ay pwedeng ma-negotiate sa isang holder in due course. Kaya meron akong papatandaan sa isang basic principle na pwede mong gamitin okay sa ibang bagay. Na ang sinasabi sa konseptong ito, na between two innocent person, dapat daw ang mag-suffered ng loss is the one who make the loss possible. Kasi between doon sa maker, saka doon sa holder in due course, sinong dapat mag-suffer ng loss dito? Dapat yung maker. Kasi nung nag-sign ka ng promissory note, fully aware ka na pwede siyang ma-negotiate sa isang holder in due course. Good faith ka, good faith din yung holder in due course, at sinong dapat mag-suffer sa inyong dalawa? Answer nga, the one who make the loss possible. Kasi kung hindi ka nag-issue ng promissory note, ay hindi sana yan napunta sa isang holder in due course. Ngayon, punta naman tayo sa section 56. What constitute notice of defect? Sabi dyan, to constitute notice of an infirmity in the instrument or defect in the title of the person negotiating the same, the person to whom it is negotiated must have an actual knowledge of the infirmity or defect or knowledge of such facts that his action in taking the instrument amounted to bad faith. In other words, class, dalawa lang ang paraan para magkaroon ka ng notice of defective title. Either number one, may actual knowledge ka, or second is bad faith ka. By the way, pag sinabing actual knowledge, it means alam mo yung exact fraud na in-employed. Alam mo yung actual infirmity or defect. Pero doon sa bad faith, hindi mo alam yung actual fraud, okay, or defect, okay, na in-employed. Pero, okay, pag sinabi kasing bad faith, meron ka raw knowledge of such fact that his action in taking the instrument amounting to bad faith. Ibig sabihin, hindi mo alam yung exact fraud na in-employed or yung mismong actual defect niya. Okay, but you know that there is something wrong about his nature of title. Kaya lumalabas, pero inacquired mo pa rin. Kumbaga, you cannot simply close your eyes to an obvious fact. Kasi kung defective siya, okay, alam mong there is something wrong, pero inacquired mo pa rin, nagbulag-bulagan ka, nagtanga-tangahan ka, in that case, okay, mako-considered siya na ikaw ay in bad faith na. Now, kaya kung halimbawa negligence lang yan, simple negligence is not equivalent into a bad faith. Hindi yan, pwede ka pa rin maging holder in due course dyan. Pero kung yung negligence mo, okay, is gross na, is so gross, amounting to bad faith, then papasok din yan dito. Okay? Doon sa pangalawang, okay, instance. Kasi dalawa yan, di? Actual knowledge, and second is bad faith ka. Now, sabi ng US Supreme Court, in order to show that the defendant had knowledge of such facts that his action in taking the instrument amounted to bad faith, it is not necessary to prove that the defendant knew the exact fraud. Kasi kung alam mo yung exact fraud, actual knowledge na yan, ay hindi naman kailangan na actual knowledge lang eh. Kasi pwede rin na may knowledge ka of such fact that his action in taking the instrument amounting to bad faith. Kaya sabi pa dyan, it is not necessary to prove that the defendant knew the exact fraud that was practiced upon the plaintiff by the defendant assigner. It's being sufficient to show that the defendant had noticed that there was something wrong about his assigner's acquisition of title, although he did not have notice of the particular wrong that was committed. It is sufficient that the buyer of a note had notice or knowledge that the note was in some way tainted with fraud. It is not necessary that he should know the particulars or even the nature of the fraud, since all that is required is the knowledge of such fact that his action in taking the note amounted to bad faith. Tandaan nyo ha, dalawa lang ang paraan para magkaroon ka ng notice of defective title. Either may actual knowledge ka, ibig sabihin, alam mo yung exact fraud na in-employed, or pangalawa, may knowledge of such fact ka that his action in taking the instrument amounting to bad faith. Problem. Rolando intended to buy a car, so an old friend, Roger, who is an agent, okay, to sell the car belonging to Delgado Clinic. Now, after negotiation, Rolando decided to buy said car. Okay, he drew, upon request of Roger, a cross-check for 600 payable to Delgado Clinic as evidence of his good faith, but which will merely be shown to Delgado Clinic by Roger, who received said check. Now, the check would then be returned when Roger brings the car and its registration certificate for Rolando's inspection. For failure of Roger to bring the car and its certificate of registration and to return the check, Rolando issued a stop payment order to the Drovey Bank. In the meantime, Roger paid the check to Delgado Clinic for the hospital bill of his wife and was given 158.25 as change. Delgado Clinic filed suit against Rolando to recover the value of the check. May Delgado Clinic be considered a holder in due course, hence entitled to recover, decide with reason. Actually, this is a bar exam question. Okay, pero galing yan sa actual case ng De Ocampo versus Gatchalian. Ang sabi ng Supreme Court dun, okay, baling lumalabas dito, itong si Delgado Clinic, okay, kung okay, ano natin, same dun sa case ng De Ocampo versus Gatchalian, Delgado Clinic is not considered a holder in due course because meron na siyang knowledge of such fact that his action in taking the instrument amounting to bad faith. Unang-una, okay, hindi man lang nag-inquire si Delgado Clinic bakit ginagamit ni Roger ang personal check ni Rolando pangbayad ng hospital bill. Pangalawa, hindi equal ang amount ng check doon sa hospital bill. In fact, sinuklian pa niya ng 158.25 dito. At ano ba ang legal effect ng crossing of check? Sabi ng Supreme Court, may tatlong legal effect ang crossing of check. Number one, it serves as a warning that the check has been issued for a definite purpose. Kaya ibig sabihin, pag nakakross yan, warning sa lahat yan na yung checking yan ay in-issue for a definite purpose. Kaya ibig sabihin, kung ikaw ay mag-a-acquire ng isang cross-check, dapat mag-inquire ka sa nature of title ng transferor. Okay, kasi kapag hindi na-serve yung purpose ng crossing of check, okay, at di ka nag-inquire, okay, doon sa nature of title ng transferor, then you are acting in bad faith. Meron ka ng knowledge of such fact that his action in taking the instrument amounting to bad faith. Pangalawa, okay, sabi ko nga, hindi equal yung amount ng check doon sa hospital bill. Ibig sabihin, hindi yan yung purpose ng issuance ng cross-check. Sinuklian pa niya. Okay, yun pa nga, hindi siya nagtataka dito si Delgado Clinic, bakit ginagamit ni Roger ang personal check ni Rolando pambayad ng hospital bill. In that case, Delgado Clinic is not considered a holder in due course. Kaya yung defense dito na absence or failure of consideration pwedeng gamitin against Delgado Clinic because Delgado Clinic is not a holder in due course. Ngayon, meron tayong dalawang defenses. First, real, saka personal. Yung real defenses daw are defense that are available against all parties including a holder in due course because the defect is attached to the rest or instrument itself. Kaya pag real defense, pwede mong gamitin against any holder na yan, including a holder in due course. Pero pag personal defense daw are defenses available to prior parties among themselves but not against a holder in due course. Kaya sabihin, pag ang defense mo personal lang, holder in due course yan, hindi mo pwedeng gamitin yung personal defense mo. Okay, pero kung holder not in due course yan, o pwede mo nang gamitin okay, ang personal defense against a holder not in due course. Okay, kaya sabi ko sa inyo, nagiging relevant lang ang distinction between holder in due course and holder not in due course if there is a personal defense. Kasi kapag, okay, holder not in due course ka, you are holding the instrument as if it were non-negotiable. Kaya subject ka both sa real and personal defense. Now, I want you to familiarize what are personal and what are real defense. Okay, so personal defense, yan yung section 14, okay, section 16, section 13, section 12, section 28, section 55. Maraming 55. Kaya doon sa section 14, ititawag na incomplete but delivered instrument. Section 16 is complete but undelivered instrument. Section 13 is insertion of a wrong date. Section 12 is antedating or postdating. Okay, section 28 is absence or failure of consideration as well as partial failure of consideration. Okay, and of course yung section 55, meaning inacquired mo yung instrument or signature thereof by fraud, duress, force and fear, or other unlawful means or for illegal consideration, or when he negotiate the instrument in breach of faith or other circumstances amounting to fraud. Yung real defenses naman, yan yung section 15, incomplete na, undelivered pa. Okay, next, okay, is infant under section 22, saka yung Corporation Act Ultra Vires. Section 23, forgery or want of authority. Okay, bali 23 yun, forgery, saka yung want of authority, 23 din yun. Material alteration under section 124, by prescription and fraud in factum or fraud in esse contractus. Okay, ngayon, punta tayo dun sa section 14, 15, saka 16. Ito yung laging tinatanong sa bar exam. Pero sa CPA board exam, hindi masyadong tinatanong. Pero by the way, punta tayo dun sa section 14 muna. Ito yung tawag nating incomplete but delivered instrument. By the way, class, i-summarize muna natin. Yung section 14 kasi, di ba? Incomplete but undelivered. Section 15, okay, incomplete, tapos undelivered pa. Saka section 16, complete but undelivered. Mapapansin mo, yung section 14, isa lang ang defect niya. Okay, incomplete, pero naka-delivered. Yung 15, dalawa na. Incomplete na, undelivered pa. Yung section 16, okay, isa lang ang defect niya. Lumalabas is complete, pero undelivered. Now, ganito kasi yan. Meron daw kasing dalawang stages bago maging liable yung mga nag-sign doon sa instrument. Una yung tinatawag na mechanical act of writing. Na kailangan yung instrument must be complete in all material particular. Ngayon, pag na-complete na in all material particular, liable ka na ba? Hindi pa. Kasi meron pang second stage yung delivery for purpose of transferring title. Kaya yun yung dalawang stages. First is the mechanical act of writing na kailangan complete siya in all material particular. And second is the transferring of negotiable instrument for purpose of transferring title. Kaya ibig sabihin, yung una, yung isa, incomplete. Ang kulang yung first stage, di ba? Lumalabas is, yung mechanical act of writing na hindi siya complete in all material particular. Pero dineliver. Pangalawa, yung section 15 naman, parehas defective yung first and second stage kasi hindi siya complete kasi hindi complete in all material particular, tapos second, walang delivery for purpose of transferring title. Yung section 16 naman, isa lang ang defect niya kasi complete in all material particular pero walang valid delivery. Unahin natin yung section 14. Legal basis sabi dyan, when the instrument daw is wanting of any material particular, the person in possession thereof has a prima facie authority to complete it by filling up the blank therein. Ngayon, dalawang part ito. Unahin natin tong first part. Okay, halimbawa, meron blank paper. Pinirmahan ko. Tapos, dineliver ko sa iyo yung blank paper. Okay? O kaya pwede, sorry. Yung first part bagay natin. Yung second part kasi yun. Yung first part, binigyan ko nung kita ng cheque. Meron ng date, may signature, may name ng payee, pero walang amount. Okay, pag binigay ko sa iyo yung cheque na ito, na walang amount, ang presumption kasi ng batas, ino-authorize kita na i-fill up yung blank. O kaya pwedeng iba naman ang nakalagay. May amount siya, pero walang name ng payee. Again, parehas pa din yung concept niya, ang presumption, ino-authorize kita na i-fill up yung blank. Yung second part naman, binigyan kita ng blank paper, pinirmahan ko. Pero, alam ko na ito ay i-convert mo into a negotiable instrument. Okay? Yan ay section 14. Pero kung binigyan kita ng blank paper, for autograph signing, at kinonvert mo yan into a negotiable instrument without my authority, lumalabas, hindi yan section 14. That is a fraud in pactum or fraud in esse contractus. Okay? Now, ibig sabihin, yung covered ng section 14, pumirma ka sa blank paper, pero alam mo na i-convert siya into a negotiable instrument. Pero kung pumirma ka ng blank paper for autograph signing or signature comparison lang, pero kinonvert yan into negotiable instrument without your authority, hindi yan covered ng section 14 because that is a fraud in pactum or fraud in esse contractus. Okay, illustration class. Tingnan mo to. Halimbawa si M, nag-issue ng promissory note payable kay P or order. Okay? Nilagay niya, I promise to pay to the order of P. Blanco yung amount. May pirma ni M. Pero inauthorize ni MCP na i-fill up yan up to 5,000. Kasi pag binigyan niya kita ng promissory note na may incomplete in all material particular, I repeat, ang presumption ng batas, inauthorize ni MCP na i-fill up yung blank. At ang authority given by M to P is up to 5,000. Ano to? Before completion, tama ba? Before completion yan. Kasi wala pang amount eh. Pero si P ang ginawa, pinil up niya ng 20. Ano nangyari nung pinil up ni P ng 20? Di na complete. Ang problema si P, ni-negotiate kay A. At take note na acquired ni A yan after completion. Take note walang nagiging holder in due course pag na-acquired mo yung instrument prior to its completion. Kasi ang isang requirement ng holder in due course, it must be complete and regular upon its face. Diba? Kung na-acquired mo yung instrument before completion, hindi ka magiging holder in due course. Kaya i-correlate mo to sa section 52. Pero once na na-fill up na siya, it means na complete. Kaya kung na-acquired mo, in-acquired mo siya in good faith and for value, it means you will attain the status of a holder in due course. Kaya lumalabas si A, holder in due course. Ay ang sabi dito, di ba? In order, however, that any such instrument when completed may be enforced against any person who became a party thereto prior to its completion, it must be filled up strictly in accordance with the authority given and within reasonable time. Ibig sabihin, kung titinan mo muna natin itong dalawa, huwag mo na lang isama si A. Between MP, kung gustong ma-enforce ni P yan kay M, dapat i-fill up yan ni P in accordance with the authority given. Kaya dapat i-fill up yan ni P hanggang 5,000 lang. Pero ang problema, kung pinil up ngayon ni P ito ng 20,000, which is beyond the authority given by M, at napunta raw kay holder in due course, it becomes valid and effectual for all purpose in his hand. And he may enforce it as if it has been filled up strictly in accordance with the authority given and within reasonable time. Kaya ibig sabihin, kung si P ang mag-enforce ng instrument kay M, pwedeng mag-set up si M ng defense kay P na hindi ako liable sa iyo for 20 kasi ang authority mo lang i-fill up hanggang 5,000 lang. Pero sinasabi ng batas, pag napunta na sa holder in due course yan, yung defense ni M, okay, na lack of authority kay P or acting beyond the authority given, hindi na pwedeng gamitin kay A. Kaya pwede nang ma-enforce ni A yung 20,000 pesos against M. Kasi yung defense dito ni M is just a matter of a personal defense na pwedeng gamitin kay P but not against a holder in due course. Kaya nga sinasabi dyan, tingnan ba ito, but if any such instrument after completion, ayan after completion daw, na negotiate sa isang holder in due course, it is now valid and effectual for all purpose in his hand. Okay, and he may enforce it as if it has been filled up strictly in accordance with the authority given and within reasonable time. Gets nyo? Yan yung 14. Punta naman tayo sa section 15, yung tinatawag na incomplete, okay, not delivered instrument. Sabi dyan, when an incomplete instrument has not been delivered, it will not, if completed and negotiated without authority, be a valid contract in the hands of any holder as against any person whose signature was placed thereon before delivery. Kaya ang ibig sabihin lang nito, okay, ang binanggit dyan in the hands of any holder. Kaya kasama dyan, pati holder in due course. Okay, example. Okay, halimbawa, okay, gumagawa ako ng cheque. Nilagyan ko na ng date, pinirmahan ko na, okay, tapos nilagyan ko na ng amount. Pero bago ko ma-fill up yung name ng payee, biglang may emergency. Kaya, okay, may tumawag. Sabi sa akin, kailangan akong makausap personally. Kaya ang ginawa ko, okay, nilagay ko yung, okay, cheque, yung checkbook doon sa drawer. Tapos nilock ko, sabay alis. Ang problema, nakita pala ako nung katulong ko. Yung katulong ko, dati pala tong miyembro ng Akyat Bahay Gang. Okay, tumingin-tingin siya doon sa table, na-curious siya. Okay, sabi niya, ano kayang ginagawa dito kanina ni Koya? Okay, kaya may nakita siyang paperclip. Kinuha niya yung paperclip, sinundot-sundot lang ng konti, okay, yung sa may drawer, bumukas agad. Kaya nakuha niya yung cheque. Okay? Tapos, pinil up niya, sabay alis na. Ang problema, napunta sa isang holder in due course. Ang tanong, syempre, nung nalaman ko pag uwi ko, nawawala na yung cheque, nag-stop order payment. Kaya nung present ng holder in due course sa drawing bank, dinishonor. Si holder in due course, hinahabol naman ako. Ang tanong, liable ba ako? The answer is no. Sapagkat ang pwede kong gaming defense dito ay section 15, which is an incomplete and undelivered instrument. And that is a real defense na pwedeng gamitin against any holder, including a holder in due course. Section 16 naman. Okay, ito naman tinatawag na complete but undelivered. Sabi dyan, every contract on a negotiable instrument is incomplete and revocable until delivery of the instrument for purpose of giving effect thereto. As between immediate parties, sino bang immediate party? Halimbawa tayo dalawa. Okay? Si P, okay, nag-endorse kay A. Si P and A are immediate party. Eh kung si A napunta ngayon kay X, okay, lumalabas remote parties na siya. Remote party. Other than a holder in due course, the delivery daw in order to be effectual must be made either by under the authority of the party making, drawing, accepting, or endorsing as the case may be. In such case daw, the delivery may be shown to be in effect conditional or for a special purpose only and not for purpose of transferring the property in the instrument. But when the instrument daw is in the hands of a holder in due course, a valid delivery thereof by all parties prior to him so as to make them liable to him is conclusively presumed. And when the instrument is no longer in the possession of a party whose signature appears thereon, a valid and intentional delivery by him is presumed until the contrary is. Okay, tinawa may illustration ako dito, wala. Okay, ganito kasi yan. Halimbawa si M, okay, ang ginawa niya, nag-issue siya ng promissory note. Okay, I promise to pay to the order of B 100,000 pesos on December 1, 2020, then sign M. Okay, complete siya in all material particular. Tapos, binigay niya ngayon kay P. Pero may specific instruction na ito ay only for safekeeping. Okay? Kaya ibig sabihin, between MP, hindi pwedeng ma-enforce ni P yung instrument against M. Bakit? Kasi yan ay for safekeeping lang. Kaya pag ako hinabol ni P, si M pwedeng mag-set up ng defense na yung delivery niya rito ay conditional or for a special purpose and not for purpose of transferring property on the instrument. Kasi yung delivery dito, hindi to literal na delivery. Kasi nasa iyo nga yung possession ng promissory note, pero may specific instruction for safekeeping. Pero ang problema kasi si P, ni-negotiate kay A. At in-acquired ni A yan in good faith and for value. O sinasabi ng batas, kung si A ay holder in due course at hinabol ngayon si M, hindi pwedeng sabihin ni M as against A na hindi ako liable sa iyo kasi yung delivery ko kay P is only conditional or for safekeeping lang yan or for special purpose and not for purpose of transferring property in the instrument. Pwedeng gamitin niya ni M kay P but not against A as a holder in due course. Kasi yung defense mo dito, okay, na yung delivery ay conditional lang or for a special purpose is only a matter of a personal defense na pwedeng gamitin against a holder not in due course. In fact, may presumption sa batas eh. Ayan natin na mo may gino, paki-bold mo yung conclusively presumed. Ibig sabihin, kapag halimbawa yung instrument daw ay napunta na sa isang holder in due course, magkakaroon ng tinatawag na conclusive presumption of valid delivery. Kaya hindi ka pwedeng mag-present ng ebidensya, di ba? Pag sinabing conclusive yan, you are not allowed to present evidence to prove, to contradict those presumptions. Pero kung halimbawa, hindi yan holder in due course, ang presumption may valid delivery, but rebuttable siya. Kaya nga kalagay dyan, and when the instrument is no longer in the possession of a party whose signature appears thereon, kaya halimbawa, ako yung nag-sign kulwari, wala na sa akin yung instrument. O ang presumption, nagkaroon ako ng voluntary delivery. Pero, rebuttable siya. Pero as long as a holder in due course is concerned, may tinatawag nga na conclusive presumption of valid delivery. Problem. Okay, June was about to leave for a business trip. As his usual practice, he signed several blank checks. He instructed Ruth, his secretary, to fill them as payment for his obligations. Now, Ruth filled one check with her name as payee, placed 30,000, okay, thereon, endorsed and delivered it to Marie. She accepted the check in good faith as payment for the goods she delivered to Ruth. Eventually, Ruth regretted what she did and apologized to June. Immediately, he directed the Drovey Bank to dishonor the check. When Marie encashed the check, it was dishonored. Question, is June liable to Marie? Okay, ano ba to? Section 14, 15, or 16? Answer, Section 14. Diba sabi doon, when an instrument is wanting of any material particular, any person in possession of it has a prima facie authority to fill up the blank therein. Eh di ba inauthorize dito ni June, yung kanyang secretary, okay, na pinirmahan niya na gamitin yan for payment ng business expenses. Kaya may authority si Ruth. Pero pambayad ng business expenses. Eh kaso, nag-exceed si Ruth ng kanyang authority. Ginamit niya for personal use. Okay, ang problema, napunta sa isang holder in due course. O, ang tanong, can a holder in due course enforce the instrument against the drawer? The answer, of course, is yes. Bakit? Kasi yung defense niya, matter of personal defense lang, hindi pwedeng gamitin against a holder in due course. Now, number 2, supposing the check was stolen while in Ruth's possession and a thief filled the blank check, endorsed and delivered it to Marie in payment for the good he purchased from her, is June liable to Marie if the check is dishonored? Iba na to, Section 15 na. Since incomplete and undelivered na siya, pwede mo siyang gamitin against any holder, including a holder in due course. Okay, Section 58, when subject to original defense daw. In the hands of any holder other than a holder in due course, a negotiable instrument is subject to the same defense as if it were non-negotiable daw. Okay, but a holder would derive his title through a holder in due course and who is not himself a party to any fraud or illegality affecting the instrument has all the right of such former holder in respect of all parties prior to the latter. Okay, ibig sabihin ang sinasabi dyan, okay, kapag holder ng in due course ka raw kasi, hindi ibig sabihin na hindi ka makakakolekta. Ang sinasabi lang ng batas, kapag holder not in due course ka, you are holding the instrument as if it were non-negotiable. Ngayon itong second sentence dito, ito yung tinatawag nating holder in due course by subrogation. Okay? Sa American jurisprudence, okay, sometimes ang tawag dyan is okay, yung tinatawag nating class na no. Okay, ano nga ba yung term na ginamit dyan? Okay, nakalimutan ko eh. Okay, i-recall ko na lang. Okay, by the way, ganito yan. Halimbawa si A, nag-issue ng promissory note, na-recall ko na. we called it actually a shelter principle. Okay, in fact, natanong yan before sa bar exam. Okay, what is the shelter principle? Di ba pag sabing shelter kasi parang shelter is bahay. Di ba? Bahay, protection siya. Kaya ibig sabihin, kahit hindi ka raw holder in due course, pero kung na-acquired mo raw yung title mo sa isang holder in due course, protected ka. Okay, yan yung tinutukoy doon sa second paragraph. Okay, but a holder would derive his title through a holder in due course and who is not himself a party to any fraud or illegality affecting the instrument, has all the right of such former holder in respect of all parties prior to the latter. Example lang. Halimbawa si A, nag-issue ng promissory note, payable siya kay B or order. Tapos in-endorse niya kay C, pay to C, sign B. Tapos si C in-endorse naman kay D, nag-pay to D, sign C. Eh si D, isang holder in due course. Later on, ni-negotiate niya kay E. Pay to E, sign D. Pero, ang problema si E, hindi siya holder in due course. Kasi kung wari, hindi lahat ng element ng Section 52 are present. Pero hindi naman siya party sa any fraud or illegality affecting the instrument. Ang sinasabi lang ng batas dito, kahit hindi raw holder in due course si E, okay, ma-acquired niya yung right ng isang holder in due course. Protected si E. Okay? Provided kailangan niya munang i-prove na si D ay isang holder in due course. Pero baka tanungin mo ko, sir, kailangan pa bang i-prove na holder in due course si D? Eh, may presumption nga sa Section 59 that every holder is deemed prima facie to be a holder in due course. Answer, kailangan pa rin niyang i-prove na holder in due course si D. Kasi wala na yung presumption because D is no longer a holder. Kasi ang holder dito si E na. Okay? Eh, paano kung ganito? I-modify natin. Si A nag-issue ng promissory note payable kay B or order. Tapos, ni-negotiate kay C. Data C sign B. Tapos, si C ni-negotiate kay D. Okay? Tapos, si D ni-negotiate kay E. Isang holder in due course. Tapos, na-reacquired ni C. Assuming si C hindi siya holder in due course. Eh, kaso na po na sa holder in due course. Na-acquired ba ni C ang right ni E as a holder in due course? The answer is no. Ang effect lang niya, you go back to your prior rights. Balik ka lang doon sa dati mong rights. Kasi lumalabas dito, you cannot simply elevate your status to holder in due course by simply transferring it to holder in due course and reacquire it. Kaya babalik ka lang dito. Parang sa successive endorsement lang. Babalik ka lang doon sa former right mo dito. Okay. Now, punta tayo sa section 59. Sabi ng section 59, every holder is deemed prima facie to be a holder in due course. Kaya ibig sabihin ko, halimbawa, A to B to C to D to E. Si E ang present holder. Ang presumption ng batas, si E ay isang holder in due course. Pero pag na-prove daw na yung title ng any person who negotiate the instrument is defective, no? Na-prove na ang title ni si defective, ang burden of proof nasa iyo. Kailangan i-prove ni E na isa siyang holder in due course under section 52 or i-prove ba na si D ay isang holder in due course para mag-apply naman yung section 50, 58. Okay, tinatawag na holder in due course by subrogation. Okay, kaya sabi niya na every holder is deemed prima facie to be a holder in due course. But when it is shown that the title of any person was negotiated, the instrument was defective, the burden is on the holder to prove that he or some person under whom he claims acquired the title as a holder in due course. But the last mentioned rule does not apply in favor of a party who became bound on the instrument prior to the acquisition of such defective title. Okay? O, yan yung okay, section 59. Okay? Bali, dito muna tayo mag-i-stop sa section 59. Kasi bali yung section 51, okay, holders yan eh. Hanggang section 59. Bali, ang i-discuss natin, bali for next meeting is now section 60. Okay, yung section 60, ito yung lumalabas na liability ng parties. Okay, yung section 60, yung liability ng maker. Section 61, liability ng drawer. Section 62 is liability ng acceptor. Section 65 or 66 is liability of the endorser. Okay, kapag section 65, yan yung person negotiating by delivery or by qualified endorsement, and section 66 is general endorsement. Okay, yun ang i-discuss natin for next meeting. Okay, okay, medyo na late lang to lang. Okay, now, goodbye.